Welcome to Studying Law Around the World. I'm Claudio Klaus. In each episode, I talk with lawyers, law students, and professors from different parts of the world to talk about legal education, careers, and what the profession looks like in real life. We talk about the hard parts, the surprises, and the decisions that shaped their paths. Whether you're planning to study abroad, thinking about working in another legal system, or just curious about how law works around the world, this podcast is for you. Today, I'm joined by Bruno Maggi, a partner at BM Advocados and one of Brazil's leading competition and antitrust lawyers. Bruno has extensive experience before Brazil's competition authority, CADE, advising on complex merger reviews, cartel investigations, leniency agreements, and regulatory matters. He's also a pioneer in private damages actions arising from cartel conduct in Brazil and has helped shape this developing area of law. Alongside his practice, Bruno teaches at the University of São Paulo and a few other institutions, while remaining active in the international legal organizations, such as the International Bar Association. Bruno, thank you so much for joining me for the podcast this evening.
Thank you, Claudio. It's a great pleasure for me and very proud to be here and to try to share some thoughts and some words about the legal world here in Brazil with you.
I really appreciate it. How did you come to focus your practice on antitrust law and economic regulation?
Actually, I started to work with antitrust and competition law some years ago, let's say that more than 20 years ago. I started as a trainee. I need to say that it was not totally planned because I entered in a law firm, a very big law firm here in Brazil. At that time that I chose to start my practice in M&A and corporate law. And then the antitrust lawyers and partners that time look at me, they're like abandoned, doing not so much. And they asked me to help. They were totally busy with major cartel defense that time and asked me to work with them to help, to assist a little bit. And it was 25 years ago and I'm still there. And actually, I got in love with antitrust and I always liked to study economy, math, and all this, all these thematics that most of times are not that one that the lawyers like more. But I was always much more involved in this logical and rational part of the disciplines since the high school, etc. And then it was, I think, it was a very good chance for me to improve my knowledge in economics, and then I started to study more and more. I did my master's in this field, and in the end, I'm still there working with competition and antitrust. The next step after the transaction is prepared and the transaction is really concluded, then I need to understand everything and do a little bit more, that is to get the approval before the antitrust authorities when we are talking about M&A clearance request. But more than that, I can explore the other sides of antitrust, the compliance, the investigations, and the damage claims. That's why I think I completed all my personal purposes with this professional, not totally planned career.
That's amazing. What a nice ending you got to that, right? So I really appreciate you mentioning it. And for those listeners who are outside of Brazil, CADE is the main competition authority. It's similar to the FTC in the US and the European Commission's Competition Directorate. And your work includes, as you said, merger notifications, investigations, the leniency agreements before CADE. So I'm curious, can you tell us a little bit about how CADE operate in practice, and maybe even what does your day-to-day work with it look like?
Sure, I can explain a little bit more on how CADE operates. It's a little bit closer to the European perspective. I mean, we have only one authority that takes care of everything here, differently from US that they have the FTC and the DOJ that splits a little bit the work. But here we do everything in CADE. And if it refers to clearance requests for M&A transactions, or if you are dealing with investigations, we do everything with CADE. And when we talk about my day-to-day work, we split maybe in 2 or 3 different parts of work, talking about what we do more in my law firm. Why? because I started the antitrust damage litigations here in Brazil, this practice, much more focused for the plaintiff side. And this nowadays, this takes about half of our time. Then it means that we are not dealing with CADE, but we are working before courts. When we do the antitrust damage litigation here in Brazil, everything is before courts. Again, very similar to Europe, and in this case also to US. And what we do, we get cases that arise from condemnations from CADE. And after all the investigation, CADE finishes an investigation finding guilty some companies and applies fines and all the penalties. After that, when we get this decision and we see that there is a lot of effect on the market, we have some clients that came to us and they ask us to try to recover the damage that they suffered because of the cartel. Because here in Brazil, that is similar to US and also Europe. When the authority penalizes a company or an individual because of a cartel practice, this is only a fine that goes to the state, but this is not indemnization for the victims of the cartel. And what we do is going before courts, before a civil court here in Brazil, and we seek for the damages. That's a civil damage, but we have all these other economic approach and all these calculations that are actually relying on the antitrust side of the CADE's decision and also economic studies of the market that was affected by the cartel. And this is something that we started here in Brazil. We are now dealing with hundreds of companies that are victims of cartel, and this takes about half of our time. But from the other 50% of our time, we do what I'm used to say that's the traditional antitrust work that is now splitting again in two other parts. Part of time we take with merger clearance requests, and part of our time we deal with investigation. Nowadays, we are dealing a little bit more with clearance requests, but this varies period to period. And the Brazilian economy is now boosting a little bit more because of the Chinese investments and many other investments that we are receiving since the beginning of this year, since the end of last year. And that's why we are a little bit very busy with the M&A transactions, and in my case, with the clearance request. The last one, talking about the investigations, then this is much more exciting because cartel investigations are always very exciting, not only because it's more complex, the work that we need to deliver is very complex. We need to analyze all the evidence. We need to prepare when we are in the defense side. Most of times it's tougher because if our client is really guilty, and sometimes it happens, then it's much more difficult to be creative and to find a solution and to find some spots, find a defense to our clients. And most of times there are lots of funny facts among of the evidence during the investigation. In the end, although it's tougher and much more time consuming and struggling, it's much more struggling for us to work with that because it's really tough. In the end, it's funnier because most of times we have a lot of specific situations that can occur with our client, interacting with the authorities. And for me, I get a lot of fun doing that, although it's very serious. And for sure, we deal with it as more professional as possible.
It's amazing. I can see you smiling as you talk about your profession, and it's just one of the fascinating things that I find here in the podcast is seeing so many lawyers that are really just happy doing what they're doing, and I really do see that smile on your face as you're sharing a little bit about your work. That's so amazing. And your practice is quite broad, it spans from competition law, corporate matters, regulation, consumer law. So there's quite a few things that you really have to be on top of. And in a way, I think it's fair to say that Brazil is a jurisdiction where we do have some constant updates, especially on regulatory matters, right? So you have to just really stay on top of your game for that. But I'm curious here, how do these areas overlap when you advise clients who are facing these antitrust risks? And maybe if you can, would you be able to mention some of the most, high complexity or high stakes situations that you have dealt with in these proceedings?
Okay, yeah. Well, I think we are crazy because we are dealing with lots of very boring things as lawyers, but we like, I don't know why. But going to your question, yes, I mean, in Brazil, I think that it's much more difficult to deal with other areas like tax law, for instance, because you need to be very updated every day. Maybe now that we are passing through a reform of the tax system, you need to be very updated every hour because the government changes everything every hour. It's crazy. In my case, I'm happy with the antitrust because we are a very dynamic area, but it's sufficiently slow to allow us to get in touch with the change, and we get some time to reach some change not only in the legislation or the normatives from the antitrust body or even the jurisprudence. Then, although it changes, we can say maybe every day or every month, it's not everything that changes. We have like a small changes that are for sure creating a better environment. We're creating some innovation in very small things that in the end, when you look 1 year back, for instance, we can see that's a lot of change. But in the end, it's something that is dealing with what we did in the past. It's like a construction of a building that every year maybe we have a new floor, but it's not like a destroying everything to renew in a totally different way for the next year. And well, we have some very exciting things. I personally like to mention two works that I did in the past. One that's quite new. I mean, it's a case that I worked with 2 years ago. We concluded it now in 2024. It was very funny because it's a client of mine that he was not aware. I mean, it was not my client, but when we get to my office, started to talk about the case and said, "No, I have a process before CADI. I did a M&A transaction some years ago, but it was not a problem. It was a very small transaction. It was not mandatory to ask to require the antitrust clearance before CADI, and everything was very nice, everything very quiet. But I don't know why I received an official letter some years ago, and they started to investigate my transaction. But as I know, everything's again is very quiet, everything is very nice. And then I said, okay, but why are you here? I said, one of my lawyers from another area, I don't remember which one, talked about you and said that you're a very good specialist. And I talked about this process before CADI, that is not a problem. But he said, you may talk to Bruno. And then I'm here. I said, okay, give me the number of your process. And I started to research very fast. I'm sorry to say that. I know you have a lawyer, but you are condemned by CADI. You probably will need to pay around 3 to 4 million Brazilian reais in fine. That's around a million Canadian US dollar, a million Canadian dollars. And he said, how? I said, well, ask your lawyer, but I think something is going wrong. If you want, you can hire me to find out what's going on, but something is very wrong. Well, to just make this very short, it took it took around like 3 months to solve the problem to this client and 2 years more to get to a very final solution. But the next day he hired me. They are like 2-3 days to be judged by the CADI. I flight to Brasilia and got a flight and meetings and blocked everything and started to discuss the case with all the commissioners and explained that it was a big fault. The process was conducted totally wrong. But in the end, it's missed. We managed to split the fine by half. The client paid less than 2 million. It was a great win. And we made a very big change in jurisprudence. Then after that, CADI didn't have a proper limitation to define. I mean, there is a limitation. This was a gun jumping case. Okay, the client didn't require the clearance request before CADI before implementing the transaction. Then CADI just investigated that market, found that transaction, and then fined it for gun jumping. And in this case, there is a limitation in law that 60 million reais, that's about 15 million Canadian dollars. This is the limitation by law. I mean, every transaction is limited by this big range by law. But that time we never had a limitation based on the transaction price, because in this case the transaction was very small. And although the transaction was very small, the fine was costing a lot of money to the client. And due to this case, we changed the jurisprudence in CADI, and now we have two limitations. The very big one given by law, but we have another limitation based on the value of the transaction due to this case that we ran before CADI in this case. And now everybody's very happy because my colleagues, my friends that I find, oh, Bruno, I'm using your jurisprudence, my client's paying less. So, oh, I'm proud about that. And this was a very funny case, but very difficult. And in the end, we got a very good conclusion. This is one that I like to mention because it's new, and it generated a big impact, not only for the client, but also for the antitrust community here in Brazil, because this was an issue that was annoying a lot of lawyers and clients, but nobody never reached before a conclusion to establish a limitation based on the transaction value. And now we have it. And this is one. And the another is a case that dates, I think, 20 years back. I was very junior in that time, but I always remember this case because it was a battle here in Brazil of two giant companies for tea. You know, these cold teas that you buy in the supermarket in the big bottle. And that time in Brazil, and I think almost all in the world, we used it to have only two different kinds of tea. Mostly in Brazil, I think, because one was the green tea. I think that you know Lipton iced tea. Everybody knows Lipton green tea is based on black tea. And you take the leaves of the black tea and boil it, and then you produce the tea. And the other one was the mate tea. That's a very Brazilian one, but you have a lot in Chile, Peru, that's made of the mate, the different kind of tea. This was much before the green tea, the white tea, all these teas that you have in the supermarket nowadays. But that time in Brazil, we have only three different brands. One that was Lipton iced tea from Pepsi, the other one that was Nestea from Coca-Cola, and the third one that was Mate Leão, that is a Brazilian brand, and it was the leading one. Maybe Claudio knows that because Claudio is from Brazil.
Absolutely. And I grew up drinking
Mate Leão.
Yes.
Yes. Then Mate Leão, that was the leading company in Brazil, was acquired by Coca-Cola. That was already producing the black tea, the Nestea. And they tried, but I was hired by Pepsi. That case, not me by myself, but the law firm that I used to work. And then we started to fight before CADI to defend the because in the end, you would convert the market from three competitors to only two. And for those that studies antitrust law and also economy, you know that if you have a market of only three agents competing, it's a very bad situation. But you have only a duopoly, it's even worse. The only worst thing that you can get is if you have a monopoly. But then it was a very funny case and very nice, very tough. We fought it for more than 2 years before CADI to convince them that the merge of Mate Leão with Coca-Cola would be like a disaster to the market because it would turn the marketing a duopoly. And in the end, we forced Coca-Cola to make an agreement with CADI, and they bought Mate Leão, but they were forced to abandon the operations of Nestea that was returned to Nestlé that used it to have a joint venture with Coca-Cola. Then in the end, it was a very great result because we kept three competitors, just changed. Coca-Cola left the Nestea partnership with Nestlé, started to run the Mate Leão business, and my client, very happy, Pepsi, continued to sell Lipton iced tea. But after that, all the other teas entered the market, the white tea, the red tea, the green tea, and now the competition is much much more intense. But that time was very important to keep the competition of the the black tea and the mate, because they were the only ones that we used to have.
Wow, really, really interesting leading cases that you had the chance to work on. Quite an interesting story, and it seems like beyond the what you just explained, that has a lot to do with the cartel cases that are also something that you work on, right? So you've been defending clients in these proceedings and negotiating agreements in the cartel cases. Can you tell me a little bit about, how has the cartel or anti-cartel, I guess, enforcement evolved in the country as well over the past few years? That's incredible. It really, I personally have never had much contact with this specific area of antitrust and cartel law, and it's just sounding so interesting, really piquing my interest here. I also saw that something else that you do is something, I guess, very international in nature, is that you lead the practice of civil claims for damages caused by cartels in Brazil, which is still developing in other jurisdictions. So I'd love to hear what does that mean, and maybe are there a few challenges that you see in building this type of private enforcement in Brazil?
Sure. Yeah, this is something that I am passionate about, because I created all this, the first book written in Brazil about this subject was mine, and I created all this theory around how to mix the civil law and the competition law. Actually, it came from, this accident that put me in the antitrust area, because I was working with competition law, but I in the professional side, but in the academic side, I always dedicated my studies to civil law. I gave lots of civil classes. I did my master's in civil area, and then when I studied my master's here in University of São Paulo, I put together mixed both words. I put civil law together with antitrust law, created this civil responsibility theory arising from the antitrust and torts. And then after that, I just wrote my thesis and just forgot it. But after some years, I started to be seeked by clients and started to see cases started by the civil prosecutor officers, the public prosecutor officers. And then I started to act in this area and to defend the victims of the cartel. And then I started to study not only in Brazil what was going on, but also in the other parts of the world. Then I learned that in the US and also in Canada, everything was much more developed. In Europe, they were not so far from Brazil. Then we can say that in Europe, they started maybe 10 years before Brazil. And then we are now, when we started to work sometimes together, I started to talk with many other law firms from US, from Europe, trying to make connections, to make joint case. And then we have, as I told you, during this period from 2005 to 2015 in Brazil, we had like these very big cases investigated by CADE that were international cartels. And in this case, although the cartel was international, it created effects all around the world. Then we had Swiss companies creating damages in Brazil, Brazilian companies creating damages in US, American companies creating damages in France, because they were all together making a big coordination and illegal conduct, but creating conditions to change the prices all over the world. In some cases of products that were produced in some part of the world, but sell to all the other parts, or in other case, situations that we are dealing about very big projects that involves parts of pieces of mechanisms of a big equipment that are produced, all around the world, some pieces of that putting together in another part of the world and sell to another country. And then in all these cases, we have, civil litigation in many different countries. Then we are dealing with still today, although we are now working more with the latest cartels that are more Brazilian ones, but we still have lots of cases running that deal with this situation that we are, seeking for damages in Brazil, but other victims had already won the case in, France or in Germany or in Spain or in UK or in US. And now we are dealing about the same case here in Brazil, but for sure for different victims, for different companies. Then this is something that we are working a lot, and we see now, for instance, last year we almost took a case that was a Brazilian company impacted by an international cartel, and we almost started a case in Switzerland. Now we are working with another case that maybe we will start a claim before Australia, because we have most of the companies that made the cartel. Just to give you an idea, each of the cartel, I think that's 6 or 7 different companies. 3 of them are from India, one is from Australia, another from Austria, and another from Germany. Then in the end, none of them are Brazilians, and all the damage was generated in Brazil because the buyers are all in Brazil. Then we can start the case, for sure we can start the case in Brazil, but we have this potentiality of starting the case outside of Brazil, because actually the effects are suffered here, but the producers, the origin of the effects is outside.
That's incredible. Wow, that's so interesting. And I'm glad you brought up about how you studied these matters deeply in the academic sense as well. And I noticed here as I was preparing for the show today that you studied in some of the best institutions in the country, but you didn't stop there. You're also a professor in many of them. So I wanted to hear a little bit about that too, being someone who practices law in such an interesting capacity, in such interesting cases. And not only that, you're also, educating the next generation of lawyers. How does teaching really affect your practice? What are some of your thoughts on that?
Well, this is a very interesting part because I love to teach. I love to give classes. In the last years, I dedicated a lot of time for the IBA, the International Bar Association, that I was an officer for many years in a very important and big committee of the organization. I gave classes from 2006 to 2024. I was always giving classes for economic or antitrust or civil law, most of times for all of them at the same time. On Monday, civil classes, on Tuesday, competition law. But anyway, it is very difficult to coordinate everything. I think it was easier for me when I was younger. Maybe I'm getting old, but we get tired about that, because when you teach, and this is something that nowadays we see, people just want to talk and just want to say something, but it's difficult to say something meaningful for the other people and just, and really teach something for the other people. And when you really, prepare for your classes and prepare everything that you give, I mean, if it's a speech or if you're a class or anything that you are doing, the preparation is very important, and the preparation is very time consuming, and for sure takes you a lot of energy. You need to study a lot, and I was very happy. As I told you, I love to teach. I love to speak about subjects that I know, and it was very important for me. Nowadays, I meet a lot of former students that are now partners in big law firms. They are, sometimes in the other side of the table, fighting with me, the other side of the case. It's very nice. I'm very proud of finding these people that really appreciate what they learned, and they see that we put an effort on share with the other people our knowledge. And sometimes we learn much more that we are prepared to teach. This is something very important, and something that I found during my career as a professor, that there's plenty of times that you learn much more with your students than you are supposed to teach. And this is very important to have this sharing of knowledge, of information, and also not only about technical knowledge, but about soft law and how to deal with the people. And then you can get from the other side when talking about international relations that we have. Not only maybe sometimes I give international classes, but also international speeches and in seminars and in conferences. It's very important to to be always open to learn and to understand the other side, not even if they are no younger or not so, expert in something, you always have something to learn and for sure to teach. And this sharing of knowledge and information, I think that's the most important thing when you are speaking about anything or if you are teaching, and the mix of generations is always very profitable for both sides.
That's beautiful. That's beautiful. I really appreciate you spending all this time with me this evening. And to wrap up today's episode, I wanted to ask you, what kind of advice would you give to young lawyers who want to build a career in competition law or work with authorities or regulators, both in Brazil or abroad?
This is difficult always because it's difficult to put in the other shoes. But what I can say is you need to study a lot. If you are talking about competition law, it's tougher because you need to learn about the economy, you need to learn about regulatory law, and you need to learn about M&A, corporate law, then as many as other areas that we have. And I think that's more and more in this future of law that we are seeing. You need to learn more than a very specific area of law, because you need to be broader. You need to understand the real problems of your client. You need to understand the real connection of the law. Not if you are, maybe you are not like a labor law, and then we talk about labor because it's very specific and different from corporate law, but maybe you are not a labor law, criminal law, but you need to have this, at least a feeling, or at least a very slice of part of the knowledge about the other parts of the law, because otherwise you not be able to really advise your client properly. And then tip I can say is to study a lot. You need to study really hard to not only solve the problems of your client, but also to be prepared to solve other problems in the future, and not only to pass in the examinations, but really to know about law and to know about what you want to learn. And the second one is to be very authentic. I think this is something that happened to me a lot. You need to be authentic. If you like somebody, you talk to that person. If you don't like, just don't talk. You have like billions of people to talk. You don't need to talk to that person that you don't like, because the other side, maybe that person will not like you as well. Then you don't need to waste your time. And the same way, you need to learn what you want, because again, maybe you can hear from somebody, if you are a competition lawyer, you'll be very rich, very successful. Or if you'll be a tax lawyer, you'll be very rich, or a criminal lawyer. In the end, if you are happy with your career, if you are doing something that makes you happy every day, to wake up and to go to your office and to work, I think this is the richest thing that you can have, because otherwise you'll be miserable every day going to your work and complaining about your life and don't liking what you're doing. Then even if they pay you millions, it will be a very poor life. Then if you are authentic and you study what you like, you do what you like, and you prepare yourself to be the best one in what you like, you'll be the unique person in that side, and this will be great because they will pay more for you if you are the unique person that knows that thing. But maybe you have like dozens of others that do what you're doing, but no problem. If you are happy or doing what you do, if you do the best way that you can do and provide a good service, you still get a lot of money and you'll be successful. And more of that will be, I think you'll be happy with your life. Otherwise, there is no reason to be there. I think that study a lot and be authentic maybe are very good tips and advice that I can share with everybody that
Absolutely.
experience.
100%. I think that's an excellent piece of advice, and to be quite fair, one that we don't hear a whole lot in the podcast. So I appreciate you bringing this up. We hear a lot about networking and hear a lot about personal branding, which are also very important, of course. But it's always good to hear a few different things, and I think from your story, you really showed us how you made a career out of being authentic and really taking the most out of the opportunities that maybe you didn't plan before but were given to you, and you just made the most out of it and became a really happy and successful lawyer in it. So I appreciate you making the time to be here in the podcast once again, Bruno.
My pleasure, Claudio. As we say here in Brazil, if they give you lemons, make a lemonade.
I love that. Thank you so much for tuning into today's episode, and we'll see you on the next one.
See you.